what's happened is they are charged, of course, in a document what's called an information. And that information is here in Surrey Provincial Court. But the nature of the offense is such that the Crown has the choice to do what's called a direct indictment, which is what they did here, which means then that the matter will no longer remain in Provincial Court, it will go directly to Supreme Court. Now, it would normally wind its way there in any event, but in this way, it gets there tomorrow. So it will appear in Supreme Court, downtown Vancouver, tomorrow at 10 o'clock in Supreme Court chambers, so that they then have the jurisdiction to deal with it thereafter. And the charge here in Provincial Court will be stayed. It doesn't really change a lot other than it changes the venue.
You've had a chance to talk to your clients. How are they doing right now?
I spoke with John last night for a couple of hours, and well, as you can appreciate, anyone in custody is not necessarily overjoyed with their circumstance. But I think he's doing about as well as can be expected. Amanda, I didn't chat with terribly long because it was my direction to her that she must obtain other counsel, so I didn't want to speak at length with her.
What did John have in his name?
He had a letter of some information. I'm sorry. He had the Quran.
Why is the Crown going this route as opposed to keeping it here in the Supreme Court?
I'm sorry?
Why is the Crown going this route to go directly to the Supreme Court?
Well, you know, that's a question that's better answered by the Crown, although in past experience, it's simply because it's a very complicated, lengthy matter, and to have a preliminary hearing, it doesn't make a great deal of sense. Duplication of just a great deal, and so I'm presuming that part of the reason is simply because it just makes more sense on a cost analysis basis.
Have you been able to ascertain or get any information about the nature of the evidence against your client?
Limited, and that's part of one of the reasons why I wanted to adjourn it over. In fact, tomorrow when I appear in Supreme Court, I will simply make the application there that I was going to make today, which is that I go over for a couple of months so that I can get the masses of materials and start to go through them.
What do you suspect you'll actually be dealing with? How many pages of documents? What sort of
Boy, this is pure speculation on my part, but I would say likely several thousand.
Could you talk about Mr. Reynolds'
At the present time, I can say that both Amanda and John are being held in segregation, which is, you all may know, is a 23-hour lockdown. They're allowed out for 1 hour a day, which makes it difficult, if not impossible, for them to speak to counsel. And my understanding is that the correctional system has made that decision for their own security. And so, again, you can appreciate someone locked in a cell for 23 hours a day. It's difficult.
That's here in Surrey pretrial?
Here at Surrey pretrial for John Knuckle, and Amanda is at the Alouette Correctional Center for Women.
Will you seek bail for your two suspects?
What do you expect will happen in a week as far as a plea, entering a plea, the likelihood of that, bail?
Right, again, as I say, tomorrow I will adjourn it over likely for a couple of months. So very little is going to happen. The matter that was here that was adjourned for a week, it's going to be stayed. It will not appear back here again. Once we appear in Vancouver tomorrow, everything will thereafter be in the Vancouver Supreme Court.
So
Do you
what's
suspect
happening on
there's
the
any chance
16th?
that they'll get bail given the severity of the charges?
That'll certainly be something I canvass with my client. I will leave that to Amanda and her new counsel as to how and when they make the decision for bail.
But will your client ask for it, do you think?
After I've had an opportunity to review all of the materials, I'll make a decision as to whether or not it's appropriate. I suspect, to be honest, everyone is anxious to achieve their release, and so I suspect at the end of the day I will ultimately do a bail hearing.
Do you suspect that they will move now that the case is being moved? Is that where they're being held?
Oh, I see. I honestly don't know the answer to that. That's strictly up to corrections.
Wait, we're talking at 9:30 on the 16th.
Sorry?
Wait, in the court, you were talking about putting something over to the 16th.
As I was just saying, that's the information that's here. That will be stayed
At that date.
tomorrow
Okay.
when we appear in Supreme Court. So the matter will never again appear here in Surrey Court.
It's premature, but what about a potential plea at this point? Any thoughts about that with your client?
Well, you know, as is so often the case with minimum mandatory sentences, if they're convicted of the 83.2 terrorist charge, there's a minimum mandatory sentence and either convicted or plead guilty. So really at the end of the day, there's no incentive to plead guilty. Well, they're married. They were married under the Islamic faith, and they're very devoted to each other. I'm not surprised that they were happy to see each other.
Can you tell us, you mentioned John was carrying a Quran. How much has his religion played a role in sort of getting him through the past week or so?
I haven't had that discussion with him.
The police were very public in making the allegations and laying out what they think. I'm just wondering, with regards to speaking to your clients, that kind of thing, the attention, what concerns, if any, that gives you?
Well, you know, a defense counsel is always concerned that a particular spin is put on it, that the way in which it's presented is not objective. I think many of the comments were a bit over the top, quite frankly. I think that the police are obliged, as any other person or persons involved in the criminal justice system, until such time as the court has rendered a decision, should remain objective and dispassionate. I don't think that the police comments were that, and so I'm a bit concerned about that. But again, I think in the fullness of time, the evidence will come out that might perhaps undermine some of what they were suggesting.
And from
like
what we've
radicalization, references to Al Qaeda, are those the kind of references you?
Those are the sorts of references I mean. Many of those are subjective decisions, and perhaps the radicalization was assisted by others.
Do you know any involvement of an RCMP informant? Have you gathered any information about what role they may have played?
Again, well, it's very premature. It is my understanding that there was, as we've all come to know it, as a Mr. Big operation. There was that component to this investigation.
Was there?
Say to that end, we've heard neighbors, that kind of thing, talking about other, somebody in a silver pickup truck, all that kind of stuff. Haven't been any other arrests. What can that tell us about what may have gone on?
I leave it for you to speculate as to what that suggests. Again, not having read the evidence, but I think it's safe to assume that certainly various of those people that were seen by the neighbors were likely undercover operatives. A very high hurdle to clear. I think it's safe to assume that there are certain elements of that. As to whether or not it sufficiently constitutes the legal definition of entrapment, again, that remains to be seen.
Were there any U.S. authorities involved in this? Do you know?
Sorry?
Any authorities in the U.S. involved in
Yes,
this?
my understanding is that there were.
Do you know who, or can you flesh that out?
No,
for
at
us?
this point it would be, I'd be only guessing. I believe I know, but I have to wait until I've had an opportunity to review the materials.
How are your clients' families feeling? Have you spoken with them?
I spent quite a bit of time with John's mother, and as you can appreciate, like all mothers, has trouble accepting that her son was involved in such a matter, and as I said to her, well, the extent of the involvement remains to be determined.
in Surrey, you think that could affect the case?
I have to tell you, I was a bit concerned by that, and I haven't had a chance to speak to my clients in detail. I'll have to look into that.
Any thoughts?
Well, often is the case that my clients direct me that there's information that may be important to their defense, that may be located, in their car or somewhere, and I may, from time to time, have to be called upon to retrieve that information. But in this case, of course, with everything having now been gone through, although I will say that at the end of the day, it probably wasn't such a bad thing, because John was very concerned about his cat, and with the media having attended there, arrangements were made for the well-being of his cat. It's probably best that I not say too much about Amanda, as I'm not, while I'm her counsel for the interim, I would probably best leave that to her counsel.
You're saying John is strongly addicted?
Yeah, John's going cold turkey, withdrawal from methadone. And as I think I mentioned to you earlier, I've had clients over the years tell me that they go back on heroin to get off methadone. It's more addictive. And so John is now going without methadone and has for a few days. So that's, of course, contributing to his overall sense of health and well-being.
So he's not taking any medication now at all, or?
Very, very, very little.
And Amanda as well?
Again, I'd rather not speak to Amanda, as I should leave it to her counsel to do so.
By very little, you mean?
I think it's probably best to control it by just not talking to the media very much anymore.
Would it be difficult finding a jury or a venue for that matter?
No, I don't think so. To be honest with you, I have great confidence in the jury system. I really do. As hokey as that sounds, I really do. I think most people take their responsibility. Most jurors, in the sense that I have in any event, take their responsibility very seriously and do a good job.
But we're talking about months away for an actual.
Oh yeah, we're talking many months.
Years?
Possibly, and simply because the block of time that's going to be required for the trial, I would anticipate the trial to take 4 months, 6 months. I mean, at this stage, of course, again, it's speculation, and were it to do so, it's hard to find that block of time.
And no plea tomorrow. We won't expect a plea.
Oh no,
Just an appearance.
Just strictly a court appearance, remand over in custody for several weeks, so as to allow an opportunity, as I say, for the Crown to provide to me the disclosure and an opportunity for myself and whoever the other counsel is to review the materials.
Do you expect both of them will appear tomorrow in court again?
Yes. I mean, an accused person has an absolute right. While I appreciate that we have virtual justice now with video appearances and the like, an accused has an absolute right to appear in court, and it's my preference, particularly in these matters, that we